Ms Legalista here, aka Attorney Sheila. I haven't even been saying that on my last few videos. This is the second video on this LIZZO new lawsuit that is out, and this has been filed by attorneys out of California. Let me turn my phone off. I tell you, me and this phone, it always wants to go off while I am recording. This is out of the state of California, and I have already recorded one video that covers the press release that was put out by the law firm that is representing Asha Daniels. That press release gave us a good deal, some background information, and that takes us forward to where we are now, which is the lawsuit. The lawsuit is 44 pages. So, as you can imagine, I'm not going to do all of this in one sitting here. I'm going to have to break this thing up. In this particular video, we're going to start at the beginning, but we're going to go through the first part pretty fast so that we can go ahead and jump to the facts. The facts. We want to get to the facts. Let's scroll down this thing and see where we are. Superior Court, State of California, County of Los Angeles. I am telling you, there are so many cases that come out of LA. I feel like I need to hire a paralegal to just be able to copy and send me cases. Asha Daniels is the plaintiff. She is suing Big Girl Big Touring Inc. and Melissa Jefferson, aka LIZZO, Carlina Gugliotta, Amanda Nomura, and those 1 through 10. Maybe those are some other people who are being sued. And there's my phone going off. You see the complaint over here, and you see 9 things listed. And that last one threw me off when I first saw it because I did not expect that. Then we have the demand for jury trial here. And again, you see who's being sued here. We have a small introduction here that says this action is being brought by the plaintiff, and then who it's against. We all know all of that. So let's scroll on down. Jurisdiction and venue. I've already said California. They're residents of Los Angeles County, California. And then you have Asha Daniels, who is actually a resident of the city of New York in the state of New York. LIZZO's company is actually a Delaware corporation. And then let's see, she actually resides in LA County along with Nomura and Gugliotta. And then we've got some other people who are not named here. These are does 1 through 10. Let's go ahead and jump into these factual allegations, which I think take us through paragraph 37. So we're on page 4. See how fast I got us through 4 pages. I can move like that when I need to. In or about September 22nd, so it's been about a year. Plaintiff designed custom pieces for the dancers on LIZZO's tour. So Asha is a clothing designer. In or about January of 2023, defendant Nomura contacted plaintiff and requested the plaintiff join LIZZO's tour. Nomura was LIZZO's wardrobe manager and was plaintiff's primary point of contact representing LIZZO's management team. Since plaintiff designed custom pieces for the tour, Nomura reasoned that plaintiff would be the best individual to assure the dancers' clothing is altered and repaired correctly during the tour. Plaintiff rearranged her schedule, canceling her fashion show and missing out on other work opportunities to accept joining LIZZO's tour as a favor to Nomura. Let me stop here for just a second because I want to reframe the way this has just been put out here in paragraph 14. It almost makes it sound like this last part. Let me go to this last part. She's missing out on other work to accept joining LIZZO's tour as a favor to Nomura. Most people recognize that LIZZO probably has a higher following, a lot more brands that she works with, a bigger network than the defendant probably has. A lot of people would feel this might be a really great opportunity for me to even reach more people and to have a bigger platform myself as a designer. So it's interesting here that they're framing this as if Asha was doing them some sort of favor. And I'm not putting Asha down. Her work is probably amazing. I'm just talking about how the attorneys have framed this as, Asha's like, okay, well, girl, I got you. I will come do this stuff for you because I'm doing you this big favor. That is how this sounds when it's placed this way. But it's very likely too that Asha Daniels, the plaintiff, gave up work to now go work with Lizzo on tour, because you can't be on tour having to take care of everything that pops up for them and then also back in New York handling your own clients. So that's going to be a tough thing to do. So I can imagine that she did possibly give up some things. But you weigh those things out and you say, okay, so here are the advantages of doing this. Here are the disadvantages. And it's a balancing act, and you make a decision. Paragraph 15, plaintiff was looking forward to working with Lizzo and her team because of the values Lizzo portrays in public, i.e., a healthy, diverse environment with virtues of respect and empowerment of women. Unfortunately, the opposite turned out to be true. Plaintiff believes the following experiences, and you see those listed there, were allowed to take place by Lizzo's management without consequence because she is a Black woman. And so I'm skipping over some of this, and I said this in my first video, because YouTube will put you in YouTube jail if you talk about certain topics that are of a sensitive nature. It's not that they won't share it at all, but your stuff will hardly get seen. Trust me, for my videos that have some sort of advertising, I don't know, sort of like a trigger warning or something like that, they don't get shared. And these are actually topics that we need to know about. This is actually a public document that has been filed in court. I find it hard to understand sometimes how they pick and choose what is deemed to be something that should be given a yellow light instead of a green light. Okay, but that's me going off on a tangent. Paragraph 16, on or about February 14, 2023, plaintiff began working on Lizzo's tour. Plaintiff reported to Nomura, who was plaintiff's supervisor for the entirety of her employment with Lizzo's tour. The disappointing reality of working on Lizzo's tour sunk in at the get-go. Plaintiff often worked 7 days a week from approximately 6 a.m. to 2 a.m. and was frequently denied breaks by Nomura. Plaintiff's movement and communication with others were constantly monitored and policed by Nomura. Even during the rare designated days off, plaintiff was pressured to always be on her feet and available to work while she was on the tour. Plaintiff is informed and believes this directive came from Lizzo's management. Adding to the uncomfortable environment of Lizzo's tour, plaintiff was specifically instructed to never interact with Lizzo herself because Lizzo would be jealous. Plaintiff was instructed to tone it down if she was ever to interact with Lizzo, specifically referencing not to dress attractively in front of Lizzo. Nomura shared that one time Lizzo was bothered, Nomura was seen with Lizzo's boyfriend and became very upset and jealous towards Nomura. Nomura explained that Lizzo would get upset the same way with plaintiff if plaintiff interacted with Lizzo and or Lizzo's boyfriend. Almost immediately, plaintiff was introduced to the culture you see there on Lizzo's tour. Plaintiff witnessed Lizzo's approximately 10 background dancers, and you see the names there, being forced to change in and out of their clothing in small, tight changing areas during all the shows with little or no privacy whatsoever. Members of Lizzo's stage crew, primarily white males, would, and as you see, the description there, while watching the dancers rush through their outfit changes. Plaintiff expressed concern to Nomura about lack of privacy and necessary accommodations and tools Black female performers would need on tour. However, Nomura merely laughed at the dancers' poor accommodations and advised plaintiff not to alert anyone else about the issue or try to fix the issue. Plaintiff would later learn details that led her to believe this was a setup to, and you see the terms there, and in some cases fire the Black female performers. Often, the background dancers would directly inform plaintiff when they would rip their fishnet stockings or other dance gear while dancing. The first time this happened, plaintiff provided the dancer with an additional pair of stockings since there was a fully stocked inventory of fishnet stockings. However, plaintiff was scolded by Lizzo's management for giving the dancer additional stockings and instructed her not to do so again. Plaintiff was also specifically instructed to not give certain dancers, and you see there a list of items, which is very surprising, they would need or ask for, despite those items being stocked. Additionally, throughout the entirety of her employment, plaintiff was forced to hear, and you see what kinds of comments there, from Nomura. Plaintiff witnessed Nomura mock both Lizzo and Lizzo's background dancers on multiple occasions. Nomura would imitate the dancers and Lizzo by doing an offensive stereotypical impression of a Black woman. Nomura would also refer to Black women on the tour as, and you see the descriptors listed there. Plaintiff, a Black woman, was offended by Nomura's disgusting comments. Plaintiff told Nomura directly her comments and imitations were offensive, especially in a work setting. Nomura ignored plaintiff's concerns, much like plaintiff's prior concerns of the lack of privacy and accommodations for the dancers. In around mid-February of 2023, plaintiff and Nomura were transporting a heavy rack of clothing when Nomura rolled the rack over plaintiff's foot. Plaintiff stopped and informed Nomura she needed to sit down as her foot was in serious pain. Shockingly, Nomura proceeded to shove plaintiff into the rack of clothing, while asserting plaintiff should not make excuses about her foot and must help Nomura transport the clothing. Due to being shoved, plaintiff lost her balance and rolled her ankle. The following day, plaintiff came to work in Croc shoes, which minimized the pain. When Nomura noticed the plaintiff's orthopedic shoes, she demanded plaintiff to change into tennis shoes. Plaintiff explained her ankle was swollen and injured after the rack incident, and that it was painful to walk in tennis shoes. However, Nomura forced plaintiff to wear the painful tennis shoes so that she could move heavy cases while injured. Before agreeing to the tour, plaintiff was explicitly promised that she would not have to perform physically demanding duties. This made the demand to change shoes unreasonable and caused unnecessary compounded injury to plaintiff. Not only was plaintiff denied medical treatment on this occasion and others, but was also forced to be on her feet the majority of the day and denied any rest even after rolling her ankle. Despite Lizzo's team knowing of the injury, plaintiff was forced to sleep in a top bunk without a ladder, even after requesting an accommodation be made. This caused her to re-injure her ankle constantly. In addition, while being forced to help with loading heavy cases, plaintiff broke 2 acrylic nails past the nail bed, resulting in open bleeding wounds, and was expected to continue with physical labor without medical treatment. On several occasions, Nomura made statements and took physical actions to threaten plaintiff and the entire crew. One, she threatened plaintiff and others that she would, and you can see what the statements are there, when she could not find her medication. Two, she shoved a crew member in retaliation for revealing she was threatening to quit. Three, Nomura snatched food out of a local worker's hand for merely attempting to take an assigned break. Four, she expressed that she would, and you see the language there, if anyone threatened her job. Lizzo's management was well aware of this pattern of behavior. Defendant Gugliotta, Lizzo's tour manager, even requested plaintiff to record Nomura without her knowledge, which plaintiff did not do as it was both unethical and possibly unlawful. Compounding the dissolution with Lizzo's tour, plaintiff also endured some other things from Lizzo's team, as you see listed there. Specifically, there was a group chat of over 30 plus people from the BGBT team, which included Lizzo, tour management, and plaintiff. In the group message, a backstage manager sent a photo, and you can see what they say that photo was of. No one from Lizzo's management team addressed this graphic sexual imagery in the workplace appropriately. Instead, Lizzo's management found the image to be comical, further encouraging this sort of workplace culture. Again, you see the descriptor there. As another example of this, when the tour got to Amsterdam, plaintiff witnessed Nomura crew and Lizzo's management openly discussing hiring, and you see what they are interested in doing there, it says. Plaintiff felt pressured to join such activities and found a way to secure one of her few days off to escape. And let me stop here for a second, because if you go back and watch my video of the backstage of the dancers who had sued Lizzo, you will see some of these very same things being mentioned. So this is not the first time these accusations have popped up. That particular lawsuit got settled, but some of these same things cropped up regarding the Amsterdam tour that are seen now. So this is not the first time I'm hearing of what happened in Amsterdam. Enough was enough. Despite being instructed not to speak with management, plaintiff bravely decided to come forward. Later in the month of February 2023, plaintiff informed Gugliotta of the widespread, and you see what's described there, and I have to sneeze, taking place on the tour. Specifically, plaintiff told Gugliotta that the Black dancers were being mocked, objectified, and denied accommodations by the stage crew and Nomura. Plaintiff also told Gugliotta that she and her local teams were victims of Nomura's, and you see all of that listed there. Plaintiff explained she believes Nomura's behavior was motivated and stated, "It's not lost on me that I'm one of the only Black women working behind the scenes, and I feel like Namora is treating me like, and you see what she says there. Plaintiff expected Gugliotta to inform Lizzo of what was happening on Lizzo's team because she believed Lizzo would not tolerate this. Okay. Women who, after all, look just like Lizzo. Plaintiff is informed and believes Gugliotta did, in fact, relay to Lizzo plaintiff's reports of this mistreatment towards herself and the dancers. Gugliotta reassured plaintiff that this would not be tolerated. The toxic work environment continued without change. Lizzo's team ultimately fired plaintiff without notice or reason. Plaintiff was later informed by Gugliotta that everyone knows Namora is crazy. Gugliotta apologized to plaintiff several times and acknowledged that although management was aware of Namora's behavior, she would be too hard to replace, and Namora wanted plaintiff gone for speaking up. Throughout the tour, plaintiff received positive feedback for her designs and other work from performers, local crews, Gugliotta, and even Namora herself. In fact, the big girls and tour musicians requested a meeting with management to dispute plaintiff's firing, and their request was denied. Plaintiff was abruptly fired before her contract was set to end and put on a March 6, 2023 flight home. Later in the day, earlier on the day plaintiff was fired, she suffered an allergic reaction that she notified both Namora and Lizzo's management about. Plaintiff was denied medical care, was yelled at for taking time to even look for medicine, and was pressured by Namora to keep working or be sent home. Despite the industry standard for having a medical team available at least by phone, no medical attention was ever provided. Audaciously, Lizzo's management has since requested further design work from plaintiff. Due to this environment that you see described here, and also the unreasonable physical requirements of plaintiff, she suffered constant anxiety and panic attacks during the tour from this environment. She continues to suffer ongoing anxiety and PTSD after the tour, and she suffers from migraines and migraine-induced eye twitch and ocular distortions, brain fog, and fatigue. Prior to filing this complaint, plaintiff fulfilled any legal requirement or exhausted any administrative remedy imposed on her by having filed the substance of claims alleged herein with the California Civil Rights Department and has received a right to sue letter dated September 18, 2023. Therefore, plaintiff has substantially complied with all requirements for the filing of this complaint and has timely exhausted her administrative remedies. So let me stop there for a second just to tell you a little bit about what that is about. If you've watched my first video, then you may recall that I took you to the website of the legal team that is representing Asha Daniels. They actually have a lot of information on their page so that you can see that she does have her right to sue letter. And let me see if I can pull that up, because that is what they're talking about here. First, you go through the administrative process, and then you go to the point where you are, once you have exhausted that, then it's okay, you have a right to sue, and now you can actually sue the other party. Let me see if I can pull that up. There's so much open on my on my computer here, so that's just like really hard to see. All right, so this is a page for the law firm here. At the top, you see the complaint. Then you see the press release that I did in a previous video. And then you see this right to sue letter that they're talking about. And it says here, and you'll see it's from the Civil Rights Department, State of California, dated September 18th, 2023, just like she said in the complaint. Attached is a copy of your complaint of discrimination. Also attached is a copy of your notice of case closure and right to sue. So there you go. And the other thing to think about is the fact that you do have timelines that you have to meet with these things. And a lot of times people don't think about it. And I've had people call me up and say, hey, can I file this? Can I do this? And I tell them to go ahead and proceed with it, but be aware that they might be outside of the deadlines here. So as you see, it says here, to obtain a federal right to sue notice, you must contact EEOC to file a complaint within 30 days of receipt of this CRD notice of case closure, or within 300 days of the alleged discriminatory act, whichever is earlier. So then you've got the rest of this, and I'm actually going to go into that in another video, but I did want to just point that out so that you have a better understanding of what they're talking about. So I hope that brings you up to speed. I didn't think this was going to be a 20-minute video, I was trying to go through it pretty fast, be pretty clear about what was going on. If you saw me do the press release, then you know this really covered some of the same issues. I think once we get into the rest of the lawsuit, where let me see if I can pull it back up now, because now I've got like 50 million pages open. The first cause of action, remember those 9 causes of action that I showed in the very beginning? We'll start to go through those. And I think more than likely, I may kind of just do an overview and go through pretty fast because a lot of it's based on some of the same actions. And so it sort of restates some of the same things again and again. I think the piece that gets really interesting to me is this part about the assault. And I guess maybe that's where she's talking about having that whatever it was pushed on her. I think that's probably what that's going to be about. But if that brings you up to speed and you now understand what is going on with this case, please go ahead and give the video a thumbs up. Let me know in your comments. And let me stop for a second too, because let me say this. As I read some of these cases, I sometimes wonder, and I can think of some other people who have been in this situation too, and theirs was not a civil complaint, it was actually criminal charges, where you have celebrities and people who are used to having the final say about things running the show, and they're making decisions and taking actions that are not in the best interest of any of the parties involved, including the celebrity himself or herself. Usually in some cases these things are disrespectful, they border on being illegal, and now you see them getting sued and in court. And I always wonder why they don't have people around them who are not yes people. So it seems like everybody around them just continues to do what they're told because they want to keep collecting a paycheck. If they are fired, who else is going to hire them in the industry? Because then it becomes, oh, well, you couldn't work with that person. Well, what did you do wrong? Because who wouldn't want to work with this star, this celebrity, this well-known personality and get a really big paycheck? Therefore, there must be something wrong with you. So I can totally understand how employees may be hesitant to speak up and take care of themselves. And as a result, they wind up being in the line of fire sometimes. So I always wonder, why is there not an attorney around? Why is there not someone who has a human resources background who is at least kept on a retainer that the parties can go to? And I'm not talking about the employees, that the employer can go to and say, hey, am I really messing up here? And that person can tell you, yes, you are. The attorney can tell you, yes, you are. Because it appears to me like, because, and I'm guessing here, totally guessing, but it appears to me that because of their status, they're pushing the envelope on some things. They're not acting in a professional manner, and it's impacting the rights that their employees have. And now the employees really have no one to go to. And in this case, what's being alleged here, what it looks like, is that then you had employees who felt like the employer was treating them a certain way. And as a result, that trickled down to other employees. So this is really an unfortunate instance. And it just looks like there needs to be some better measures in place and some other people who are willing to say, no, you can't do that. No, that's wrong. No, here's what you should be doing. No, let's figure out a path forward to fix the mistakes that you just made. So let me know in the comments. Maybe I went way overboard with this and I'm talking too much about it. I don't know, but I just keep seeing more and more of this. And it just feels like people don't have good people around them who will speak up and tell that person who's in charge, hey, this is probably not the best decision. But I get it. People need to eat. All right. Don't forget to give the video a thumbs up, and don't forget to hit the notification bell so that you can be informed every time I drop a new video. And peace.